esteemed guests and the honorees, it's my absolute pleasure to welcome you all to this prestigious award ceremony. Today, we celebrate excellence, innovation, and outstanding achievements in the field of intellectual property and legal services. Each award we present tonight represents exceptional contributions that have left a profound impact in their respective domains. Without further ado, let's begin this celebration of the excellence. So, the first award is Patent Attorney of the Year. So, first award today is for Patent Attorney of the Year, a category that honors an individual whose expertise and dedication have shaped the landscape of intellectual property. This year, the honor goes to none other than David Sankar. David is not just a patent attorney, but also a mathematician, a software engineer, and entrepreneur with a PhD in mathematics from the University of California, Berkeley. That's my alma mater as well. Good. An extreme experience as a patent litigator and practitioner. David has worked tirelessly with clients and inventors to build robust IP protections. His remarkable contributions to artificial intelligence and the IP domain have earned him this prestigious recognition. Additionally, his entrepreneurial journey in launching Sankar IP in 2024 showcases his commitment to providing high-quality legal work at competitive prices as well, of course. Please join me in congratulating David Sankar. Congratulations. Thank you, David. Our next award is Trademark Attorney of the Year. The award goes to Josephine Rivland Robert, the Managing Director of the EGR Law. With over 25 years of experience, Josephine has built a stellar reputation as the leading attorney in the Mauritius. She regularly appears in significant cases, including those before the Judicial Committee of the Privy Council in the UK. Her dedication to advancing legal profession and her active participation in international platforms like ours make her truly deserving winner. Let's give her a big round of applause. Josephine. She's not here? Oh, okay. All right, so Josephine is not here, but Bhavish will receive the award on behalf of her. All right, yes, please. Congratulations.
I'm not Josephine.
Yeah,
by the way.
We'll change that.
Should change the name.
We will get that done. Yeah.
Put Bhavish on it.
Sure. So Bhavish we had.
No, so we have a trademark law firm.
No, that's just.
Oh, okay. All right, that's for her, and then.
The director
yeah.
of EGR.
Okay, yeah, that's for her.
Yeah,
and
I
then
know.
All right. So third award category we have is Women in IP. So it's a special one recognizing remarkable contribution by a leader in intellectual property under the category of Women in IP. This year we honor Ghada Al-Aidi, the CEO and founder of Ghada Al-Aidi law firm. As prominent lawyer in Saudi Arabia, specializing in commercial and IP law, Ghada has set a benchmark for excellence. Though through her workshops and initiatives, she has greatly influenced both private and government sectors, empowering others and advancing the legal community. Ladies and gentlemen, please join me hands in celebrating Ghada Al-Aidi. So our fourth, the final individual awards is Best Lawyer in Virtual Assets. Recognizing the expertise in one of the most dynamic and emerging areas of law. The award goes to Dr. Sanjar Muminov. an international expert in IP protection, digital asset monetization, and startup legal support. Dr. Muminov has excelled in preparing licensing agreements, providing legal protection, and crafting investment packages for brands and digital assets. His innovative contributions to legal domain make him a standout winner. Let's hear it for Dr. Sundar Muminov. Huh?
He's late, like he's not doing it.
He's not here? All right, so unfortunately he's not here as of now, but we'll celebrate with him. So now we'll move to the awards for exceptional firms that have significantly contributed to the intellectual property and legal fields. These organizations have set the gold standard for excellence. So the first award we have is a Trademark Law Firm of the Year. The award for Trademark Law Firm of the Year goes to EGR Law, known for its high-quality services. EGR Law is a trusted advisor to over 100 corporate clients in Mauritius, including some of the largest groups and statutory bodies. Their commitment to building lasting relationships and delivering exceptional results has earned them this well-deserved recognition. Congratulations to EGR Law. The Bhavish is going to receive that award. Thank you. All right, come on in. So this one is correct name. Thank you. So the next award we have is the Brand Protection Firm of the Year. The next award goes to Safe Names Limited. The Safe Names was founded in 1999 and ICANN accredited since 2002. Safe Names has been a pioneer in corporate domain portfolio management and online trademark services. Their innovative, client-focused approach has solidified their position as a global leader. Let's congratulate Safe Names on their incredible achievement. So the next award we have is Best Firm in IP Enforcement. And the honor goes to Emirates IP Services. Established in 1998, Emirates IP Services has consistently safeguarded intellectual property rights through patent protection, trademark registration, and anti-counterfeiting solutions. Headquartered in Dubai, they have extended their reach globally, ensuring their clients receive unparalleled services. A big round of applause to the Emirates IP Services. So the last but not the least, of course, the award is Patent Intelligence Firm of the Year. This final award for the Patent Intelligence Firm of the Year, it goes to Mindsoft. They're specializing in patent information tools and analytics. Mindsoft empowers organizations with cutting-edge solutions for competitive intelligence and innovation tracking. Their commitment to driving innovation in patent intelligence has earned them this distinguished recognition. Congratulations to Mindsoft. Clap for him. Thank you so much. All right, as we come to end of this award, so let us take a moment to reflect on the brilliance and dedication of all our honorees. The individuals and the firms have not only excelled in their respective fields, but also have inspired us to grow, strive for excellence in everything we do. Thank you all for joining this award ceremony. Have a great evening today. Thank you so much. Bye-bye.
Thank you, everyone. Now it's lunch time, and we'll resume the session in 40 minutes. And the lunch is on the first floor, Medley Restaurant.
Ready for another engaging and insightful session. The next session is the intersection of IP and technology, key trends and opportunities. And this session will be moderated by Aisha. I believe she's not here. That's fine. And the panel members are Mohammad Hegazi, Legal Policy and Regulatory Advisor, Hegazi and Partners, Egypt. And the next panel member is Daniel, CEO, Azami Global, Israel, and Munna Farid, Managing Director and Head of Legal, Hatch, DWC-LLC, UAE, Tushar Khandekar, Partner, IP Niti, India, and Aiden Mamadova, Lecturer and Researcher, La Baku University, Azerbaijan. Please welcome all of them. Yeah, sure.
So I think you have to introduce the panel after. You have to merge, actually.
Okay. So, okay.
I'm covering for you.
Please introduce yourself. I'm so sorry for that.
Oh my God, no worries, no worries. I mean, we don't have so many people. This is why I hate after lunch sessions, because no one is in the room. So thank you so much for joining us. So I'm Sanaz, Sanaz UK IP Attaché. I'm based in Dubai, covering for Middle East and North Africa. And my colleague Aisha, she just had a family emergency. She asked me to cover for her. So I'm moderating the session at this stage, and the next panel, I would be the speaker. Thank you so much. So we're going to start. So this is the very last minute change. You see me as the US IP attaché replacement. So I would like to, if you can introduce yourself and provide some sort of info about what you're doing, your background, the country you're coming from, your organization. And also I'm going to start with the questions and the opportunities and challenges regarding the topic. So Aidin, if you can go ahead. We don't have so many mics, but we have.
Hello, everyone. Nice to meet you here. Thank you for having me. So I'm Aida Mamadova from Azerbaijan. I'm university lecturer, PhD candidate, and coordinator of some double degree programs on IP of my university with foreign universities. So my area is IP, is innovative development and IP, their link, commercialization of intellectual property, assets, and maybe for this audience, I'm a little bit theoretical. We'll have some theoretical like speeches, and but this is very interesting to participate here because I get a lot of practical information on IP, on use of IP, on commercialization of IP, and so on. Thank you very much. So I'm passing. Share.
Yes. Thank you. Hello, everyone. I'm Tushar Khandekar, and I'm from IP Niti. And now it's been a little over 17 years for me within the IP domain. I am based out in Mumbai, India. Our head office is in Noida. So we have split team between two locations. And my education background is in material science. I'm a research scientist by education. So my primary work is to work with R&D teams from customers and help them erect their patent portfolios, especially within the Indian jurisdiction, as well as strategize with them to make sure that they have optimal coverage in all the markets that they are targeting. And at the same time, the products that they are developing, they are infringement-free, and making sure that there are no adverse effects of the products once they are launched in the markets. So that's a little bit about me. Over to you, please.
Thank you. Hello, everyone. My name's Muna Farid. So I am a lawyer by trade, and I have had the infamy of being both in-house, working for public sector in a multitude of different industries, ranging from M&A, of course, as a lawyer, and FMCG, healthcare, and now I've been working with a group of people who consult in the areas of technology. I primarily focus on going to market, so it's about how do you actually enter this market or operate out of this market, creating partnerships, creating legal framework, as well as the right ecosystem players around. My personal sort of role is that I also act as interim head of legal as well as business development officer for these companies, including interim COO and CEO. So my sort of interest in IP, of course, comes from having managed very, very large portfolios all over the world. In addition to that, I think now I'm primarily focusing on AI and technology and bringing strategy as well as guidance in that space for companies. I'm currently seconded to a very large multinational, helping them shape their AI strategy, their major partnership in the region, as well as being one of the execution specialists on their responsible and ethical AI framework. So I'm really looking forward to speaking today more about this with my panelists.
Okay. Wow. Cary, Levitt, I think you see on the information that my colleague Daniel was scheduled to be here today. He could not join, so he asked me to participate in his place. So it's nice to see everyone again. So again, I'm a U.S. patent attorney. Most of my career has been in-house with multinationals, and I'm working now for a company named Azami Global, which is a tech-driven IP solutions provider, and I can tell you a little bit more about that. And I actually have one favor, and maybe this is true for everyone on the panel and all the panels. If you haven't given me your business card, I'd be grateful if you could give me your business card today. So I want to be able to stay in touch with everyone here that we've met. So sorry about that, but I think that's
That's why we're here.
it's a good reminder.
So I mean, if I want to provide more info about my background, as I said, like I'm covering for my U.S. counterpart for this panel. This is a very interesting panel. We just changed, like replacing everyone with someone else. So my name is Sanaz. I'm an IP lawyer with business background, coming originally from Iran, just moved from Switzerland. I've been working with Swiss IP Institute, EU IPO, and WIPO for decade, and I just moved to Dubai to work with the UK IPO as the IP Attaché responsible for Middle East and North Africa. I'm based in Dubai. I sit in the embassy, but this doesn't mean that I issue visa. So my responsibility is not visa or consular advices, but we work on the IP framework in the region, working with the government and private sector. So I'm going to start with you. Sorry? Thank you. So I'm going to start with you, Aydin. So you mentioned that intellectual property system is almost under development in Azerbaijan, and there is the development, or if I may call like a gap between university research and also industry. So how would you see the current situation, and what are the solutions you think for filling the gap between research and commercialization and putting the technology into the market in Azerbaijan?
Thank you very much. Yes, in Azerbaijan, intellectual property rights began to develop after, the collapse of Soviet Union and the country's independence. So since then, a fairly developed legislative system and institutional system of IP protection was established. And indeed, as you mentioned, it's seen from statistical data that there is certain gap between innovative results and innovative innovative opportunities created by the state of Azerbaijan. So we know that the world experience shows that there is a positive relationship. There should be such relationship between the level of creation and use of intellectual property and the country's economy. In Azerbaijan, such correlation is still not noticeable. And the reason one of the reasons of this I see in the weak commercialization of innovations. Here there are, yes, many reasons, in fact. Low investment attractiveness, for example. But I would like to share with you firstly the positive tendencies in my country, which like improving the situation. For example, some achievements which can lead to commercialization of innovations in universities and research centers. So, first of all, necessary legal basis has created for it, in accordance with the law on science. The universities and scientific research institutions were granted statute of public legal entities. This means that after it was adopted quite recently, and it means that now universities themselves are the owners of property rights, including IP rights. This, of course, can be the incentive for the development of research activities in universities. Then there was established commercialization and transfer of technology center in 2022. This center there is just one center in Azerbaijan. It's created under the Agency of Intellectual Property of Azerbaijan. Of course, just one center is not enough, but it's a kind of first step in this way. Also, technology innovation support centers have been created. Their aim is to provide patent information to participants of the innovative processes and increasing innovational potential. What is the problems and what can be the suggestions for the improvement of the situation? In my opinion, there are several important points. For example, first one is formation of official legal positions of universities and research centers on IP issues. In other words, IP policy. The problem is our universities do not have some strict IP policies, IP management, in other words. Then also establishment of rules for distribution of the results of commercialization in universities. So who will get profit from these inventions, patents of universities? Then for the next one is maybe we should give preference to those intellectual property results which have commercial potential. And another very important point is increasing IP literacy, IP culture, IP education, and also business skills in this area. Despite the legislative system is okay. I mean, we have about 15 legal acts on different areas of intellectual property. But still, the awareness of IP in Azerbaijan is weak. Maybe this comes from, this reason of it is our Soviet past, where there were no private property, and that's why also the notion of intellectual property, in fact, didn't exist maybe in legal system. And finally, implementation of measures related to availability, openness, attractiveness of research for venture capital owners and potential investors of private capital. Of course, and the last one is transfer of technologies, technology transfer between universities and industry. In other words, important question is how to put innovations, bring innovations out of the walls of the universities. So to bring them to market, to make them work. And of course, in this case, they will influence positively to the economic growth of a state. Yeah. Thank you.
I have a question beyond what Aisha sent to me. So, are you also, because I heard some international cooperation projects happening in Azerbaijan. Are you aware of any that are you doing like any collaboration with other IP offices, with WIPO, with international organization for developing the relevant IPS strategies? And also, I didn't get if you still have the national IPS strategy in place or it's only in a university level.
Yes, our IP, we do not have concrete IP strategy. Let's start with this question. So, but there was the program adopted by the decree of the president, in which there are key points are to develop non-oil sector, to develop research and way of education in the universities, then to increase investment attractiveness in the country, and so on. So yes, all these points, they have one common condition: development of the IP and the development of the effective enforcement of intellectual property, not just in laws, in paper, but in reality. This can be called the IP strategy as well, in fact. So what was the other question? Yes, Azerbaijan is a member of WIPO, and we are not a member of WTO, unfortunately. But yeah, but cooperation is made in the level, on the level of agency of intellectual property. So we have one agency which regulates almost all the areas of IP. This is very centralized body. Coming to cooperation in universities, it's only starting. It's on its rise, kind of. Yeah.
So it's at earlier stage for the time being.
Yes.
Okay, thank you so much. We'll get back to you later on. So, Ashur, please, I mean, as you might be aware, the USPTO AI strategy was released just last week, and which is highlighting the transformative role of AI in facilitating working with both inventors and also patent examiners. So, in your opinion, how AI-generated inventions and other new technologies, such as 3D printing, challenging existing IP framework? From your perspective, how right holders leverage AI and blockchain technologies can leverage AI? From your perspective, how can right holders leverage AI and blockchain technologies to better protect and manage their rights?
Sure, thank you. So I think I'll start with basically the question of AI, how the adoption of AI is actually going to help in the overall examination process, as well as how the IP holders are going to be benefited. So if we talk about the overall patent examination process, traditionally speaking, if I may dare say, that the examination has always been very, very focused on the jurisdictions by the examiners where they are examining the applications, and not too much of attention used to be paid to foreign prior art. There are several challenges from the examination perspective when it comes to foreign prior art. One of them is the language barrier. So that's exactly where the use of AI is going to be immensely beneficial in examination, because now the resources that the examiners have at their disposal are numerous, and the reach of data that they have access to is enormous. So that's where the examination is going to be of high quality from almost all patent offices. Of course, examiners willing, but definitely the quality is going to increase. And when we say the quality is going to increase, then we are going to get high quality patents that get granted, as opposed to the relatively higher ratio of patents that were of low quality, which came out of a lot of tier 2, tier 3 countries as patent offices. So that is definitely going to improve. And well, there is a downside to that as well, because as lawyers, we might see a downward trend towards revocations or invalidation proceedings that go into courts. But overall speaking, it is going to be very, very beneficial for both the examination procedure as well as the IP rights holders, especially patent holders, because the high quality patents ensure that they stand the test of time in courts as well as invalidation proceedings going forward. So the patent holders will be able to rely much more on the IP that they get granted from the patent offices and will be able to enforce them harder on any possible infringers of their IP rights.
So I would assume that like right holders can use AI and frontier tech or blockchain technologies for like the whole IP management life cycle, from the prior art search, examination side, toward the management and monitoring of the rights and down to enforcement, right?
Absolutely, absolutely. Yep.
Yeah, so do you have any other point to add, or otherwise we pass to Mona?
Yeah, I think we can pass and then come back.
Yeah, sure.
Thank you.
So, Mona, this is actually a common question to you and Cary, but if you like, both of you answer or Mona answer, and I can raise another question to you, Cary, at the later stage. So, Mona, from a legal policy perspective, what are the most pressing challenges in aligning IP protection with fast-evolving technological trends in MENA region? What key policy recommendations would you make to government, IP offices, or enforcement agencies to better adapt to the technology landscape?
So I think I'm going to approach this question in a very holistic and kind of maybe oversimplistic manner, because I think you need a practical approach because of the rapidity in which the landscape, particularly with the advent of AI's accessibility to everyone, because AI has been around for a long time, has grown and continues to scale at the rapid rate. I think we're at a crossroads for sure in terms of how technology as well as the law are going to interact with each other, particularly as the scale, the volume, the rapidity of the growth of AI is such that I think it's impossible for regulators and policymakers to actually keep up. You can issue as many standards as you want, but if the actual modality, the product, the services that are being generated are moving as fast as they are, I think it's not humanly possible, at least, to keep up with that. So I would say I'll first kind of address the challenges a little bit, and then I'll try to propose a few solutions which are kind of practical. So I would say the biggest challenge from an IP legal perspective is ownership and authorship and creatorship, inventorship, right? The very definitions of when you have autonomous creativity involved in any process, I think the very question that's being turned on its head, which is a struggle for the courts as well as for regulators, is, who is an owner, and where would you be defining that? Because ownership means value. So value, why is value important? Well, why do we innovate things in most cases? Why would R&D and investment dollars be put to work if there was no incentive per se? So I think policy to a large extent is going to be driven by, where the value creation is going to be and who can be attributed to, the ownership with respect to that value. And that ownership, of course, then clarity in that ownership perspective leads to regulators and governments and policymakers to be able to define those very, very fast-moving targets. So I would say the key challenges, as I mentioned, are attribution, ownership, inventorship, as well as authorship. What is original? How do you, is using a prompt, that's a big hot topic now, is prompt engineering and, prompting creative? Should an owner who has been very good at prompting an autonomous system be given ownership? Can he own that IP that comes out of that? So these are hot, in the moment topics, right, that we're all wrestling with. Those are kind of the challenges. How do you define these things, in real time, right? And I think until the courts get involved and, the litigation continues, I think it'll be quite difficult to land in any one place. But I think it's a fair sort of point to agree that ownership is going to be a key sort of aspect of any challenge that's going to be applicable to IP. That's one. The second thing is going to be IP law, right? So I think at this point in time, there's no choice except to have a paradigm shift in the law itself. I think the IP legal system has been around now for centuries, and I think there is an opportunity for the law to accommodate some of these, changing aspects, because what would you have to actually take? It would take will. If you need to be a bit more flexible as to what an owner can be, or what a creator can be, and what can a prompt person actually qualify? I think that has to be something that the current law potentially, with a bit of mindset shift as well as value system shift, potentially can consider. So it's not that we're writing a completely new body of law and we're having to work ourselves day and night to kind of come up with new definitions and new aspects and new concepts. The system and the legal systems that are in existence and the definitions that exist probably already exist. They can be relied on, but it's going to really require an approach, I think, shift towards the existing law. So that would be that's another challenge. How do you shift it's not from just the MENA region, it's, now I think IP is international. You cannot make domestic policy in isolation. We live in a borderless world. Technology does not really recognize borders. So how are you going to address that? So I think at the end of the day, legal boundaries as sort of we know them are, I think, already a thing of the past. So how do people like yourselves, get together and actually set up the right standards or the right environment for the rest of us to have the policy guidelines? I mean, EU Act's a monster, but at least it's come, right? So it's a kind of starting position for us to kind of look at wrestling with definitions and how are we going to apply, what are we going to enforce, what are we going to litigate? What's woolly, and we don't know, and we have some opportunities there potentially, right? From these trends, there are also going to be opportunities for us lawyers particularly. So those would be kind of the aspects, that are currently the challenges. I would say that we're also at an inflection point, which gives an opportunity to shifters, people and companies with the ability to make changes, a real opportunity to be heard and to have a voice. Not just big tech sitting on all our data, because that's by compulsion to a large extent, but corporations as well as individuals, as well as society actually coming together to decide what's of value, what should be rewarded, what's ownership, what's true ownership, what's creativity, how much are we willing to let somebody protect some prompt that they engineered using hundreds of hours of their labor and putting their own element and their own creativity into it. It's not a simple task. So it's also going to be up to sort of, I think, the individual and society as a whole to be able to make those value judgments, right? And courts will eventually have to catch up with that sort of. And I would say, at the very least, I mean, I work in an area of responsible and ethical AI. So core values, corporations have, for the first time, I think, really an opportunity to be transparent and to create frameworks that allow their customers, their vendors, their ecosystem, their suppliers, everybody who deals with them, an opportunity to actually interact with a framework that sets a few boundaries, that says, okay, this is our no-fly zone. We're going to engage with you, customer. We're going to engage with you, person who's interacting with our tool. But this is kind of how we externally are going to set up a framework that you will have to comply with for us to provide services, right? So that's one way of companies to be able to address and provide solutions to some of these challenges, is communicating openly and spending the time and money and effort. Then what happens internally? So a big challenge for us was we did all this work and did an external framework. Well, then how do you enforce that internally? How do you guide your own employees from not, using every tool that comes, accessible on their phone, right? So you create also a sandboxing environment and an internal innovation environment. You create an execution focus. You create a filtration process. So there's a lot of space for all of us as lawyers and advisors to create tools and systems and processes to allow people to engage with what we're selling or what we're advising our clients on as well. So there's a lot of practical solutions as well that are possible. Governments, the only way that they're going to be able to engage is to speak to each other through the global bodies, but also internally, opening it up with specific committees and specific lawyers. Lawyers, I think, at the very least, have to make the biggest change within themselves. Because at the end of the day, we as lawyers what have we done for centuries? We have represented clients, we've managed risks, we have a risk-averse, sort of mindset. We come in there to protect and serve or help people to make money. These are kind of the choices that we really have in our profession, to put it very, simply. So where do we sit in all this place of rapid change? How are we going to service our clients and sort of society at large? Well, I think we have to make the biggest mindset shift. I think people in universities and other stakeholders have to really step up and say that, are we just going to be siloed, ultra specialists, looking conservatively at our sort of one area, and we're going to protect that? We're going to say no to everything. We're going to advise judges to say no to everything. We're going to be ultra conservative. No. Or are we going to actually move with the times and try to educate ourselves? Because I honestly believe we've come to a point when no one can say they're not a technology lawyer. Anyone who's a lawyer today is a technology lawyer, no matter whether they like it or not. So I would say that I think it's really time for us as a profession to not only train the people coming up behind us, but particularly those who are already there, all of us, dinosaurs, be able to find our way through this and be able to guide, our clients appropriately, right? And overall, I would say the most important question that I think everyone's going to have to wrestle with is, what does it mean to be human? Who is a human ultimately? That human being, how do we define that human so that we separate it from an autonomous element? And where does that sort of very fine filtration happen between what a human creates and what a machine creates, right? I think we're going to have to, those definitions, again, to come back to the most fundamental point today, is who is going to define what's created, what's an innovation, and who should get paid for it ultimately, and who should be protected for that origination. So I'll end here. I mean, I've said a lot of different concepts, but I would say policymakers have a lot of work to do. I think it's extremely difficult. I would say that at this point, the only way we can really address this is holistically. We as lawyers have to work with our colleagues in other disciplines. IP lawyers have to work with antitrust, competition, commercial, and really find strategies that work in real time. And at the same time, as lawyers, we have to shift. And lastly, I think corporations and policy providers have an opportunity to really create frameworks that are practical and easy to follow for everyone. This is the way I look at it.
Perfect. I mean, Mona, I think you put everything together in a very, Yeah, but I think the main challenge is on the Gen AI. It's not on the identification of up to what extent the AI is, generating the technology. And I think for us, you mentioned that we are all tech lawyers, but up to what extent we are capable of identification of human contribution. I worked with WIPO AI team last year, and I have to confess, it was the most difficult IP project I've been doing in my whole IP career over the last 22 years. I couldn't. I mean, for me, I don't have technical background. I have only legal background. Okay, maybe business knowledge is easier to gain rather than tech knowledge, because if you don't have technology background, it's not really easy. Especially coming from a jurisdiction that you study law. It's not like being a patent attorney and working on AI tech-related issues. So I think this is really a challenge, because even in global domain, even in WIPO, other IP, local IP offices, regional ones, I think this getting together and talking to each other is not really easy. And you see that even in global level, WIPO has a committee for each and every IP issue, but for AI and frontier tech, it's only a dialogue, it's a conversation. You know what I mean? So the pace of the technology is so fast, but how far we can go? And there would be a day maybe the AI can regulate itself, you know what I mean? So I don't know. As an IP lawyer, I'm a bit cautious about this AI and frontier tech. What's your view, Cary, on this? Especially on the policy side, what is your recommendation?
Maybe I can reflect a little bit by maybe, thinking of, you mentioned lawyers who are dinosaurs, right? So count me in. I'm a but I wanted to reflect a little bit by giving a perspective on what I remember. So somebody mentioned patent searching and the the technology and how it's advanced the ability to search patents, and examiners can deliver real high quality searches and examination and improve the quality. So my father, I think I mentioned before, my father was a U.S. patent attorney, and he started as an examiner a long time ago. And when he did a patent search, this was long before, forget about AI, it was long before we had any of the databases available. So a patent search involved going to the patent office. The documents, they were printed, and you actually had to go into the basement where they had a library. There was one person who knew where everything was located. So you'd say, I need to search patents related to pesticides or computers or whatever it is, and they'd point. And you'd go into an area of this of the basement, and you would take a box off of the shelf. They called it a shoe. I don't know if you remember that, but the boxes where the patents were stacked were called shoes, and you'd take a shoe off of it and you put it on a desk. And David, you remember this, I know. And you actually had to read the patents, right? So you had to read. So my father would sit for 3 days, and he'd read them one after another, right? And then he'd write a report that maybe took another day. So now when we do a patent search, how long does it take? I thought a few seconds, maybe, right? You type in your query, you don't even have to type it in. You can do extract the language out of a research report or something else, and you put it into the AI patent search tool, whichever. There are a lot of them now. Some are good, some not so good. And in a minute, you get the results, right? So going from 3 or 4 days to results in a matter of minutes is, where we've come on this journey. But the journey brings with it, as Mona described, very, very, very well, challenges. And the thing that fascinates me the most with this discussion, and I'm really interested to hear from everybody, is, the fascination that AI can generate content. There's some sort of innovation to it. So whether it's an audio, a video, a painting, a report, a contract, a computer program, or whatever, that's AI generated, and maybe there's some contribution by a human to it, but we have a system right now based on the current case law that says no one owns it, and there's no intellectual property rights to it. So this is the first time, I think, in history where content, innovation, some creative works have been generated. It's not owned by anybody, and there are no intellectual property rights in it. So given that background, my question is, and I have some thoughts, but the question is, what strategies do we use? What strategies do we employ while we're waiting for those judicial decisions, right, which will eventually clarify some of it? What do you tell your clients? What do you tell your corporate law departments? How do you develop policy that says, what do we do? I know one strategy for me is make sure that there is some human contribution, right? Because then at least you have something you can grab onto and say, well, we have rights. There are rights. There's some form of ownership that we can try to define. There's some intellectual property rights that we can try to protect. While, by the way, they pay us a lot of money, because that's the cool thing about all of this, because it's going to take a lot of legal thought and involvement and litigation over the years that we'll all be involved in. But what else do we do?
Cary, do you think that it's good? I mean, I don't think that it's a good comparison. Can we compare it to employment contracts, the relationship between employer and employee? Do you think that it's a right comparison, as the ownership and authorship is the main challenge we are facing at this stage?
So I don't think it's a good comparison, because remember, those contracts are designed to specifically state who owns. the rights, intellectual property, or work for hire, whether it's a copyright. So absent that agreement, then usually the employee would have some rights, but we write those agreements in such a way to make it clear that the employer, the company, is the one that retains, whatever those rights are. I'm not sure how to, draw a parallel. If you have a contract to what? You're contracting something that there are no rights, there is no ownership in the AI-generated material. So.
But you mentioned to the example that there is the AI-generated tech and the IP intersection. Do you have any successful example of implementing, having the Gen AI and also the successful of implementing IP rules and strategies in order to protect the technology?
So the one thing we talked about already, and the one thing I would always recommend, just as we said, is make sure that there's some human contribution to whatever's been generated. So just don't. I'll use my basic example. Don't use GPT, right, and generate something, and then just say, here. Make sure that you add some sort of contribution, some thought, some modification to it, so to make it your own. And then at least you can claim some form of ownership to it and some intellectual property right. Maybe that's a very simple example, but that's certainly what I would do. You're going to have,
Yeah, I would say that at the moment, that's one of the strategies, one of the only strategies, given that the courts and the regulators have pretty much said that a machine can't be a creator and inventor, at least in the U.S. And in the U.S. Legal system. But I would say that the human in the design is very important. You absolutely have to have that as a strategy. But also, maybe you have to delineate. As an employer, you have maybe an opportunity to create some do's and don'ts or rights and wrongs to be able to, especially in a company that needs to create IP. So we're looking at a very specific example. But if the IP is important to you, if your brand is relevant and you're a tech company or whatever, what have you, I would say that it's going to be very important to tell your employees, and your framework has to absolutely exemplify this, is there should be a delineation of what part was your own thought process, and you have to document everything very, very rigorously now, I think, because the outcome of what you're creating is you need to meet the existing definitions. So it's very important to say that if you created a system which allowed you to search patent, if you're using a patent system to do your research, that's fine. Okay, but if you are using an autonomous system to create a patent or a patentable technology, you better have an engineer or several engineers documenting all their thought process and all their methodology and procedures that they have employed, and protect, and really, really make sure there's rigor in that. Only then, if they're using ChatGPT or whatever tools are available to them to run some calculations or run particular algorithms or, run some testing, that's okay. But you have to make those delineations. Today, that's what I was trying to push for earlier, is that I think IP law, as we know it, is, it's almost become sort of an ideology, but that's not really where corporates and this need for ownership and value creation out of IP is going to allow us to, I think, stay there. I think the boundaries are going to constantly be pushed. So at the moment, this is all we can do, I think, for the most part. I'm sure there's many specific examples of specific things, but, which are case specific. But I would say that overall, that's the guidance, because the human is required today by almost all legal definitions, right, in the world. So, because Davos, there was a case that tested this, and at the end of the day, that's where regulators stand. And I would say, still, you do what you can, but within all of us, I think there is a duty, because, to push those particular boundaries. So I think it's inevitable that, those definitions will have to be redefined in near term.
Okay, so beyond this is a question actually to all panelists. Beyond the AI-specific rules and regulations that the governments are still struggling with, in terms of IP policies and strategies, how would you, especially for SMEs, startups, small businesses, because they're really facing a lot of challenges in protecting and securing their IP rights. So what is your recommendation? Because we work closely with the small businesses, awareness raising, training, policy, legal advice, and also recently it's so trendy to have coaching programs for businesses. So, but in the end, in spite of the fact that most businesses, they know the value of IP, they cannot develop relevant IP strategies, especially when they want to enter international market. So what is your recommendation? Because this is not only the case of developing world, it's also the case of developed world. So in WIPO, there was a joint project between WIPO and International Trade Center on coaching women-led businesses in Asia, Africa, and Europe. And the idea was successful women-led businesses who developed their IP strategy in the past lead and somehow coach the women-led businesses based in Europe, in UK, Monaco, France, in developed world. They knew the value of IP, they could develop their IP portfolio, but when it came to the management and monitoring of the rights and enforcement issues, they were like, we don't know what to do. And we don't have the access to financial resources, because access to fund is also important, right? This is why we recently talked a lot about IP and finance and the role that IP can play in securing funds for small businesses. So what is your idea, if you can share your insights on the relevant strategies for SMEs?
Sure. So I think I can take an example of how it has been, the overall space has been within India. India has seen a tremendous growth in terms of startups coming out from our tier 1 cities, as well as now the startup culture has spread onto tier 2 cities as well. And primary reason for that has been the lots of initiatives that have been taken by the government in order to foster that startup culture and foster innovation amongst all the premier institutes, the educational institutes, where actually the technology has been driven through professors, the knowledge is being imparted. So right from there, the policies, the implementation of the policies have started. And it's a tremendous push from the government in terms of establishing multiple centers in multiple cities that provide this kind of education awareness in terms of innovation, protecting the innovations, and then taking the next step towards the commercialization of their inventions. And this has been taught to all the students within the colleges, universities. Of course, at this time or up to this time, it is restricted to tier 1 colleges and universities only. But slowly the message is spreading. The government is still pushing. And we see that more and more cities are getting added every few months in terms of these courses and awareness programs for the students. So that has brought up a lot of startups in the technology side, and tremendous innovations have been happening within India. And we as IP Niti have also a motto to support all the startups that we have within the technology space within India, and make sure that they are able to erect patent portfolios of their own by providing them hand-holding, providing them education awareness on how to go and get your patent granted, and not just stopping at that, but how to make sure that you are able to enforce the IP that you own, and how to make sure that you do not allow anyone else to misuse the IP that you own. So that these programs have been helping tremendously. And I would say the issue of awareness is not just restricted to a few countries, or maybe not to tier 1 or only to tier 2 countries. But I can actually take an example of a conversation that I had with a couple of companies. One was from UK, one was from Austria. Both of these were into additive manufacturing. So developing machines for 3D printing of technologies. And I was having a conversation with them. They were displaying their new machines in an expo back in December in Bangalore. And I asked them, do you have patent protection for the new machine, the product that you are displaying today? So the guy said, yes, we have patent protection. So I said, good. In what all countries do you have? So he said, we have it in UK because we are a UK company.
Yeah, exactly.
And they didn't have protection in India. And that's where the problem is. So then I had to explain him for the next 15 minutes that how things work, how it is jurisdiction specific. And that's awareness. So I'm hoping he went back and he told his colleagues to make sure that the next products they come up with have the right protection, the right kind of markets. But that's the kind of awareness that we are speaking about. And that is where all of us as a community needs to do more in terms of coaching, spreading awareness, coaching startups, coaching maybe students right from the start, that they can choose IP as a career, and actually what is the importance of IP and what is the importance of enforcing the rights of IP within the market.
Thank you so much. This is really great. In UAE level, they have also they have started this IPS school, which is not IP Academy, it's IPS school, which is, I think, a very authentic name to educate everyone from the early ages, even in the primary school through social media, like about illegal download and, different IP issues and respecting the right of the IP owners. So, Cary, do you have any other additional points to add?
Yeah, maybe I can provide a perspective from a corporation, a multinational, because what you mentioned about a startup, of course, is very, very relevant. Education, exposing them and understanding the law and what their rights are. I can tell you that even in a multinational, that sort of awareness and training is still important. And I know years ago, I worked with a team to start what we called the IP Academy, to be able to teach even the scientists and the business representatives within the company what their rights were. So some of the scientists, all they knew was that if they developed some research, they wrote a report, well, if they sent it to the patent lawyers, they would get a $500 bonus in their paycheck at the end of the year. There was some sort of remuneration, some IP compensation for them, and then if we actually got a patent, then they got a little bit more. But they truly didn't understand the rights and what it meant, and the value that hopefully we were able to extract. So we had to teach them that, understand what a patent is, what the rights are, trademarks also. So it's interesting what you say. Critically important for startups, but relevant for multinationals as well, which is crazy.
Yeah, I think, but this is also, if I may add, this is also sector specific, because the requirement of, you mentioned, to agri-tech, for example, pharma, like each and every sector is different, right? So the IP priority might be different. Okay, each and every business needs a trademark. This is apparent. But when it comes, for example, to pharma, like not every pharma company is always to patent all the time, So again, this is when we were doing this coaching program, the mistake that most of the businesses do, especially small businesses, is like IP is all about registration. IP is not about registration. There are some other IP tools that you can use, and especially now with the AI, like, oh my God, it's not all about registration. So I think there is a huge gap to fill in, and the sky is the limit. And to end the panel, if Aiden, you would like to provide some perspective from Azerbaijan as well, yeah, because we're running out of time.
Yeah, okay. In fact, can I add something regarding our previous topic on AI? Like, there was an interesting question. Muna asked, what is human? So from this perspective, I always wonder what human has, which AI doesn't have. And it's one of the things is consciousness. So the question is, can AI have consciousness? And for me, some AI is consciousness one of the conditions for being the owner of some creation, for example. So this is just addition to the previous topic. So from the Azerbaijan perspective, I can say again, I'm joining the previous speakers that development of the awareness on IP law is very important. In my country, it's also it's not so strong; it's weak. And today we are trying to develop IP courses in the law faculties of universities, but not just law faculties, but also for other specialties, so that every student, for example, from biological faculty or chemistry and so on, can be aware of their IP rights. And the great idea is to develop IP awareness in schools from the childhood. So this is very important, one of the most important issues. And that's all, I think, what I can add to the discussion. Thank you.
Thank you so much. Thank you so much for your time. I think we're running out of time, but this has been a very interesting panel. I learned a lot. Thank you so much. And looking forward to staying in touch with you. And yeah, have a great rest of the event.
Thank you. So do we have any questions from audience?
I was just going to say, so there's the panel the sixth panel this evening is actually specifically dealing with inventorship and authorship. So there will be more on this by another panel this evening.
We're looking forward to that.
Thank you so much. Now it's time to honor our panel members and moderator. So I would like to request our moderator to do the honor. One second, let me take it. On behalf of Daniel, I would like to request Cary to please receive it.
Thank you. Thank you. Thanks for having me.
And this is for Sanaz. This is for you.
Oh, thank you so much. Thank you. Let me come to the picture.
Okay. Let's have a group photo.
All together. Be careful with this.
Very dangerous.
Tricky.
Physical things behind us.
I haven't given one to Aisha.
Sure, I will give you.
Thank you so much.
Thank you to all the panel members and moderator. I will give you Aisha's. I will give you Aisha's. Okay.